Hi guys, this is Erica from Gokce Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. On December 22nd, 2016, Carlos Andrade, a retired professor, sued hundreds of his relatives over 4 small parcels of Hawaiian land. Joining him in his suit was none other than Mark Zuckerberg. So why would the Facebook founder involve himself in a family land dispute? We'll find out at the end of this video. But first, you may have heard the term Allodial title pop up now and then while researching land due diligence. Unfortunately, there is a fair amount of misinformation about this concept. So in today's video, we have everything you need to know. Number 1, what is allodial title? Allodial title is a concept in some systems of property law. It occurs when real property is owned free and clear of any superior landlord. Historically, it was distinguished from property that was subject to a feudal relationship. Today, allodial title is often reserved for property held by governments, and true allodial title is rare. Number 2, what is fee simple ownership? In common law jurisdictions, most property is held in fee simple. In many ways, fee simple is very similar to allodial title. However, fee simple is subject to the following provisions: taxation, eminent domain, state and local laws such as zoning and building codes, and encumbrances such as mortgages or liens. Number 3, there are a number of people who wish to obtain allodial title because they do not want to pay taxes on their property or have it subject to foreclosure. So the question is often, is it possible to obtain allodial title? Well, unfortunately, the answer is no. All property in the United States is subject to the Constitution and state law, which means that at a minimum, it is subject to taxation and the right of eminent domain. However, as we mentioned earlier, fee simple absolute is a close approximation of allodial title. For, minus the 4 points mentioned earlier, it does give you absolute ownership in the land. Number 4, having said all this, Nevada and Texas did for a time experiment with allowing allodial title within their jurisdictions. Under Nevada's provision in particular, a property owner could submit an application for allodial title provided that they proved the property was not mortgaged, was being owner-occupied, and had no other liens against it. If the property owner could prove this, they could then buy out their future tax obligations by paying the state a lump sum amount. Once they paid this lump sum, the property owner would be eligible to receive allodial title and would not be obligated to pay property taxes moving forward. However, should the property owner sell the property, pass it on to their heirs, or use the property as collateral against a debt, allodial title would go away. Unfortunately, both Nevada and Texas have since removed their allodial title programs, so as of the time of this recording, there are no states in which you can obtain this form of ownership. Number 5, but let's take a moment and pretend that you can actually obtain allodial title to your property. I think we can all imagine some of the benefits that would come with allodial title, but it would also come with some problems that you may not have considered. For example, because theoretically, property held under allodial title cannot be foreclosed upon, you are not able to use it to secure debt, which means it may be hard to fund improvements. And if you wanted to add an addition to your property or build a house, you would have to pay cash. Furthermore, you would not be able to take out a reverse mortgage and use your property to fund your retirement. Of course, we are talking about legal concepts here. So if you have specific questions about ownership over your property, it is best to speak with a local real estate attorney. But let's return to Mark Zuckerberg. In 2014, Zuckerberg bought 700 acres of remote beachfront land on the island of Kauai for $100 million. His aim was to create a secluded beachfront estate for his family, but he had one problem. Contained within and around the sprawling property are about a dozen small parcels over which hundreds of individuals still have a claim, one of whom is Carlos Andrade. Carlos along with scores of others, is a direct descendant of Manuel Raposo, a Portuguese laborer who immigrated to the Kingdom of Hawaii in 1882 to pick sugarcane. From his labors, Manuel would eventually save enough money to purchase 4 beachfront parcels, creating a small family estate destined to be occupied by generations of Raposo descendants to come. Carlos is the land's current occupant and caretaker. For 30 years, he's cleared the land, harvested it, made repairs, and lived on a small off-grid cabin he built with his bare hands. Yet, Carlos is not the property's sole owner. Over 300 other Raposo descendants own fractional interests in the land, which also give them access rights to Zuckerberg's property. And so the 2 neighbors teamed up as joint plaintiffs in a quiet title action, a suit that would eventually force the sale of the property at a public auction, allowing Carlos to purchase full title to the land in question. The proceeds from the sale would be distributed proportionally among each of the descendants. Carlos would get full title to the land, and Zuckerberg would no longer have to worry that hundreds of people may end up using the parcel to access his land. But wait a minute, you may now be asking, what does any of this have to do with allodial title? Well, Manuel Raposo acquired his land from the government at the tail end of the Mahele, the great upheaval in Hawaiian land tenure that marked the beginning of private property on the islands. As part of this process, allodial title to nearly 1/3 of the king's feudal land was transferred into government hands for sale or distribution to native Hawaiians as fee simple estates. Like the Raposo lands, many of these properties were passed down to heirs without documentation, weakening ownership claims and leading to a rash of similar quiet title suits that have slowly eroded native Hawaiians' ancestral claims to their land. Yet despite what you may think, Zuckerberg's case was not a clear-cut example of a wealthy individual bullying locals. Public outrage over the suit quickly caused the Facebook founder to drop the case, along with 7 other quiet title actions he had initiated as sole plaintiff. In a local op-ed, Zuckerberg apologized for his actions and stated that large portions of his estate would be maintained for farming by the community, and that he would work with community leaders to resolve title issues on the other small parcels within his estate in a way that respected local tradition and was fair to all. But while Zuckerberg may have dropped out as co-plaintiff, he continued to support Carlos's case, stating he wanted to help the 72-year-old clear up title so he could pass the land on to his children. And 2 years later, Carlos successfully bid on 3 of the 4 parcels in a public auction. The price was $10 million, and the funds, of course, came from Zuckerberg. Now, do you have any stories about allodial title? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.